name is Sid Mendelson. On my right is Stan Judd. On his right is Sid Simmet. And on his right is Larry Bardfeld.
I had mentioned previously Section 6C, which is a rather unusual section to have in a law. In other words, Congress creates a law and then says to the administrative body, the regulator, you can exempt any person or persons from any and all provisions of this law if you think that such an exemption is necessary or appropriate in the public interest and consistent with the protection of the interests of investors. Of course, an application is required for such an order, or of course the Commission possibly could proceed by rule and exempt a whole category of companies from the provisions of the Act. And basically what this section was intended to deal with are those occasions which and entities which may spring up, which may fall within a particular provision of the Act, but one could really say that there wasn't really an intention to regulate such a company.
Well, as a matter of fact, it's a very ingenious way of regulation, in that the statute can be very onerous, very strict, and the Congress here has delegated to the administrative body, the SEC, to determine in a particular case whether a particular company, a particular person, or a particular transaction needs the protection of the statute, and to what extent it needs the protection, so that in a particular situation where the Commission finds that the protection of the specific protection of the Investment Company Act is not appropriate or necessary, it can exempt it. And that's a very ingenious method of regulation. It allows Congress to be strict and gives the elasticity, the rubber, to the Commission. And conceivably, the Commission, if it doesn't act judiciously, can be reversed by a court of appeals, so that there is control over the Commission, and at the same time there is elasticity.
One of the things the Commission is required to find to grant such an order is that it's necessary or appropriate in the public interest. And so one may ask, where does the Commission find the public interest? Is it anything that the five members of the Commission determine is in the public interest? Are they absolutely free? Or is the public interest somewhere stated somewheres? Some people have thought that the public interest that is referred to in Section 6C is to be found within the four corners of the Investment Company Act, and if not within the four corners of the Investment Company Act, then within at least those acts which the Securities Exchange Commission administers. If you read Section 1A of the Investment Company Act, I think it's possible to spell out an implied public interest under subparagraphs Section 1A3 and 4 in respectively the promotion of interstate commerce and the efficient flow of savings into the capital markets. And I think that if you could show that the relief that you are requesting is necessary or appropriate to promote or to deal effectively with those two types of subjects, I think that you might have satisfied your public interest requirement. Insofar as being consistent with the protection of investors and the purposes of the Act, that, as I've said before, you have to turn to Section 1B to see what were the circumstances in which the Congress said that the interests of investors were adversely affected, and, as you remember Sidney saying, that the 1B specifically says that the purpose of the act, in accordance with which its provisions are to be interpreted, were to eliminate, as far as was possible, these abuses which adversely affect the interests of investors.
I might say that there was a very interesting case in which the public interest was an issue, and that was the scholarship funds cases. These cases were peculiar in that they set up a payments by the investors through the interest that these investors would put into savings and loan, and which they would then assign to the scholarship plan. And this interest was invested. And in addition to the investment, if your son or daughter that you chose to be a beneficiary of your scholarship plan did not reach the second year of college, you forfeited all of that interest. Or if you stopped payments before that person went to the second year of college, you forfeited all of the payments. And this was very much like a tontine, because the scholarship plan could only work by virtue of forfeitures. In other words, there wasn't enough increments from investment income to put people through college. But if you've got people in 10 or 11 that were in 10 or 11 years, started at 6 and quit at 16, there was enough of those forfeitures that the people remaining had enough money to put their kids through college. So in order for this plan to work, you had to go down, the scholarship promoters had to go down to people and sell this plan to people who they thought wouldn't go to college. They would go either to low economic groups and to people of that sort, and they even sold some of them to people who had children that were imbeciles, and said that if the mere fact that the kid knew that he could go to college and might help him. And terrible sales practices, and they had filed for an application, and the commission felt that there were enough elements here of gambling and of tontine that it held that it was not in the public interest for them to grant an exemption.
An interesting aspect of Section 6C is that not only can the commission grant orders to take place in the future, but it can also exempt transactions or persons retroactively from the provisions of the Act. So that if somebody should engage in a transaction which under the Act is prohibited, and under other provisions of the Act, the rights of a person who engages in a prohibited transaction in violation of the Act are voidable, that transaction, even after it's been engaged in, after it's this illegal transaction, may nevertheless be exempted by the Commission retroactively from the provisions of the Act. So that, for example, take a situation where an investment company or affiliated person of an investment company may engage in a transaction with each other, buying or selling securities, which is in violation of the Act. And supposing that thereafter one party wants to, the investment company, let's say, wants to void the transaction because let's say the property that it's bought, the value has gone down. And under the Act, the transaction is voidable at its option. So it goes into court, let's say, to void the transaction, to get its money back, and the other party comes into the commission and asks for an order under Section 6C, exempting the transaction from the provisions of the Act. And the commission has indicated that it has such jurisdiction, and the courts have indicated that the commission has such jurisdiction to issue such an order.
As a matter of fact, it did issue an order in a case called American Bakeries, where American Bakeries was the downstream affiliate of an investment company. I think it was called Mathers Fund. And the Mathers Fund owned 9% of American Bakeries, and American Bakeries was therefore an affiliated person of the investment company. American Bakeries, when sugar became very scarce, American Bakery stock went down because it couldn't do any baking, didn't have any sugar. And the investment company solicited, as I recall, American Bakeries and asked them if they would like to buy their stock back. American Bakeries indicated that it would, but it sent the investment company a letter, and which stated, we want you to know that we think the stock is at its lowest point, that any increase in the sugar supply will increase the stock in American Bakeries. So if you sell it to us, we want you to know that you're selling it to us at the lowest price. Nevertheless, Mathers Fund did sell. And as American Bakeries predicted, the moment that sugar became plentiful, the stock of American Bakeries went up. It went up to the point where the stock that was sold would have been worth more than $1 million more than it was worth previously when the sale was made. And suddenly somebody discovered that no application had been filed for this, and therefore the transaction was illegal. The Mathers Fund immediately sued American Bakeries for rescission of the transaction. American Bakeries filed an application with the Commission to have the Commission declare that under Section 6C that the transaction was exempt. Well, before we did this, our enforcement branch, our Chicago office, conducted an investigation in which we found absolutely no overreaching, no withholding of information. As a matter of fact, this letter that I mentioned was a point of issue because it was so explicit that the staff thought it might have been planted after the fact. And because it so exonerated American Bakeries that it was something that one would have thought was the product of some good counsel. And but nevertheless, we found nothing wrong. We found that it was almost impossible for a downstream affiliate to take advantage, other than by sheer fraud, of the investment company. That we saw really no chance of overreaching. Consequently, the staff recommended that the Commission issue an order to exempt the transaction that had already taken place, because we felt that it would have been unjust enrichment for the investment company now, after it had gone into a transaction with its eyes wide open, was taking advantage of a mere technicality in the statute. There was a hearing, and the Commission found unanimously that Section 6C should be used to grant the order, and it did so.
I think Sidney has indicated it would probably be a very rare combination of circumstances in which the Commission would use its authority under Section 6C to grant a retroactive exemption. Obviously, I don't think that anyone is thinking that one could proceed in disregard of the Investment Company Act, and then after you've violated the Act, come into the Commission and say, give us an exemption.
In this act, there was no question that both sides of this transaction requested counsel to determine whether the transaction was legal, and counsel came up with an opinion and forgot Section 17 of the Investment Company Act. It was a case where counsel just didn't think of the proper section of the Act, and when it gave its opinion, so that there was no contrivance here or any of that sort of thing. It was a most unusual set of circumstances.
Does anybody have any questions about 6C? Well, then I'll turn to two other exemptive provisions. One is Section 6D of the Act. That gives the Commission the authority to exempt a closed-end intrastate investment company with assets not in excess of $100,000. Closed-end basically is a company that doesn't continue to issue its shares, and basically it also means a company which is not issuing redeemable securities. This exemption has been called the sort of mom-and-pop exemption. There was some thought that there might be in certain states very small investment companies that were only operated intrastate that really couldn't afford compliance with the Investment Company Act, and that therefore these companies ought to be exempted. The Act, as I said, does not provide an absolute exemption. It merely gives the Commission power to provide an exemption for such a company on application. Its relevance today, I imagine, is very, very small. There are not too many companies that are so small. The next provision I'd like to discuss is 6E. And I mentioned this before in connection with 3B2 of the Act, in which I said that when the Commission has granted extensions of the temporary exemption from the Investment Company Act, which is provided to an applicant under 3B2, such an exemption has been made, extended exemption has usually been made under paragraph 6C and 6E of the Investment Company Act. And this is the 6E that I referred to. And it says that the Commission may, under this section, make any provision of the Act applicable to a company which the Commission has exempted from any provision of Section 7 of the Act. And this section, which I'll discuss later, prohibits transactions by an unregistered investment company. And the Commission may also make an order under Section 6E applying provisions of the Act to other persons in their transactions with such company as though such company were a registered investment company. Sometimes a company will ask for a extension of its automatic exemption under Section 3B2. As you can imagine, that many times determinations under that section do not get resolved within 60 days of the filing of the application. Well, in granting these extensions, where it's not clear that what the company's status is, whether it's ever going to get an exemption or a determination that it's not an investment company, that the staff might wish certain provisions of the Act, such as Section 17, which deal with affiliated transactions with the company, to be effective during the interim period, so that it's not unusual for an extension on the exception provided by Section 3B2 to be conditioned on the application of certain provisions of the Act, such as 17, both to the investment company and to any persons in their relationship with the investment company. I think that's about all I have on Section 6. Does anyone have any questions, or else Sidney, it'll be your turn.
Okay. Any questions? Well, from here on in, we will be considering the investment companies and all entities as coming within the 40 Act, and that is the companies will either be subject to registration or will be subject to enforcement for not registering. Section 4 of the Act has to do with classifications of companies. Now, the classifications of companies are set forth. The first company that is mentioned is a face amount certificate company, which has already been discussed. This is a peculiar type of company that issues something similar to a debt instrument. It promises to pay either a sum certain or a sum which can be discerned, can be figured out, 24 months after the date of issuance. At least 24 months. It could be 10 years, but it has to be at least 2 years. And it is subject, the payments for this, the consideration for this issuance must be made in installments, except where the company does have installment contracts issued, then any type of face amount certificate is subject to this classification. That is, a company that is issuing installment types also issues fully paid types is still within the definition of a face amount certificate. Now, does anybody have any questions on that? The second type of company classification is a unit investment trust. Now, a unit investment trust is organized under a trust indenture or a contract of custodianship. It means that what that means is that the securities that this company owns will be in a custodianship, and there'll be a contract setting forth the rights of the parties, either through an indenture or a contract of custodianship. It does not have a board of directors. That's one of the essential ingredients. The other essential ingredient is it doesn't do any managing. It's exactly what it says. It's a trust. It issues only redeemable securities, each of which represents an undivided interest in a unit of specified securities. Now, what does that mean? That means this. There are several types of unit investment trusts. I'll try to describe them. The most common unit investment trust was sold, used to be sold as a what they called a not a Quinby plan, but a front end load type of contract, a periodic payment plan. Normally, an investment company, a normal mutual fund, may sell its shares at $1,000 minimum or $500 minimum. Along with that, they would have a unit investment trust that would say, well, here you can pay $20 to start and $10 a month. And as you accumulate, as money is accumulated, the unit investment trust will buy the shares of the mutual fund and hold them. And the units that you have will represent so many shares in the mutual fund. And they did this, one, that the investment company didn't want to be bothered with small accounts on its books. So the unit investment trust would be the one that would have the small accounts. And as you might guess, the charges were much higher for the small purchaser than they were for the large purchaser. And as a result, just as an aside, the statute allowed this unit investment trust, this periodic payment plan, to purchase those shares, but to charge the individual investor in the unit investment trust as much as 50% of the first year's payments. So a person who would pay $20 to start and then make 12 payments, 11 more payments of $10 each, we'll say, was subject to half of all those payments going in as a commission. A very onerous and you might imagine a very attractive tool for high pressure salesmen. So we had in the investment company business those people who couldn't sell storm doors, siding, and things of that sort, going into the investment company business, banging on doors at night, because one sale would get them quite a bit of commission, particularly if they could get the total payments for 1 year in hand. They would immediately get half of it, not telling the person that he could go into the fund at 8.5% directly. So there were all kinds of problems, which we'll get into later in the course, which mitigated the Congress to take some action to stop these front-end loads. The other unit investment trusts that we have had are what we call the bond funds, which an investment banker, such as Merrill Lynch or Bates and Company, would accumulate a series of securities, and these securities would be specified, and so many bonds of this corporation, so many bonds of that corporation, and this would be listed. What would happen would be this: the Bache or Merrill would deposit those securities with the custodian, take back all of the units that they represented, and thereupon, when their registration statement became effective, and I'm overly simplifying this, they would sell the units to the public, and the public would know exactly what portfolio they were buying. And that portfolio, except for extraordinary circumstances such as the failure of one of the companies or the possible failure of one of the companies within the portfolio, that portfolio would remain intact to the end of the trust, so people knew exactly what they were buying, and the only time they could substitute would be by order of the commission or for specific reasons which might be set forth in the indenture. Then we have another type of unit investment trust, in which the variable annuity companies came into when they came into existence. They used a unit investment trust. They would sell, in effect, the insurance company would sell they would sell the variable annuity. The variable annuity would be a unit investment trust. And then the insurance company says, now you can fund this variable annuity by going into one or two or three of our funds. For example, they would have conceivably a bond fund, a long-term fund, or a long-term growth fund, and a more speculative equity fund. And the investor, the purchaser of the variable annuity, could indicate how much of his payment would go into either one of those funds. And those units and those payments, as they were made, shares of those funds would be held by the unit investment trust. And that particular annuitant's or investor's record would be made with respect to the combination of his payments in the various funds. And then we went out, and then it even got more refined in that the insurance companies would actually buy other funds that were also selling to the public. Previously, what I told you, these were captive funds of the insurance company, registered as funds, but only selling to the variable annuity. This gave, as I say, the investor the chance to move from one investment to another, whether he wanted long-term, short-term, or whether he wanted merely income. Then, as I said, the thing became even more refined, in which they decided, well, you could buy, and I'm only say you could buy Dreyfus, or you could buy Wellington Fund, or any fund that was sold to the general public in the main. But the variable annuity company, the insurance, would have a contract with that fund that its shares could be purchased by the unit investment trust, and normally at no load, and so that the load, if any, was attached to the variable annuity, and this became a very flexible way of selling variable annuity, so that the customer, if you will, had an opportunity to choose the investment media best suited for his purposes. That's the unit investment trust. Does anybody have any questions on that? Now, I'm sure as time goes on, the unit investment trust will be put into other forms as the ingenuity of the promoters see fit to use it.
Why are they allowed to buy series of previously issued?
Well, I'll tell you very simply. This was as you know, in bond funds, if a bond fund is redeemed, and there's no market being made in those units, the bond fund will shrink, and the shrinkage will cause the sponsor to sell the portfolio. He has to. If somebody's asking for redemption and there's no money, and in this case the unit investment trust is always fully invested, any redemption causes a sale. So in order to stop that, the investment advisor, the sponsor made a market in these securities. He made a market by saying to the investor, yes, you can redeem, but you'll redeem on the bid side of the market. I'll repurchase from you on the ask side of the market. So that it was always to the investor's benefit to allow the sponsor to repurchase rather than to have the investor redeem. Well, now the sponsor is sitting here with a bunch of securities which he has to sell in competition with the next bond fund that he's going to make, the next series that he's going to put out. And obviously, he's in competition with himself. This impaired his ability to repurchase and keep those bond funds going. In other words, to stop the shrinkage. So Merrill and several others convinced us that to put the units itself rather than securities in the bond fund, up to a certain percentage, would not impair the investor's ability to get his money's worth, if you will, and would help the funds from shrinking, which could be dangerous and to the investor, in that the securities would go on the market almost on as a matter of necessity, and that being the case, the market could not be controlled and would go down, and investors would get less for their securities than they should. So we allowed this as an expedient. We didn't see any harm, and we saw a lot of benefit. So it was just a matter of them convincing us that there was no harm being done. Any other questions? Then the third type of in the classification is management companies, and unfortunately the statute says all other companies that aren't unit investment trusts and are not face amount certificates are necessarily management companies. Now, management companies, generally speaking, under our statutes, all must resemble either are or must resemble corporations. There are some exceptions, but they all have to take something similar to a corporate form. We have some limited partnerships as management companies, but you're hard put to find that these things aren't operated as a corporation. So that management companies are normally companies that are managed, as against companies like unit investment trusts that are not managed. Now, there is a subclassification in Section 5A of management companies. The first one is an open-end company. An open-end company, according to the statute, means a management company which is offering for sale or has outstanding any redeemable securities of which it is the issuer. Now, a redeemable security, generally speaking, is a security which carries with it the right of the holder to turn that security in and get his pro rata share of the company. That is what is known as a redeemable security. In other words, an open-end company, which is generally spoken of as a mutual fund. This is another, popularly, it's called a mutual fund. It is really an open-end company. When a person decides he wants to get out of an open-end company, he gets the net asset value per share. Generally speaking, net asset value per share is nothing more than assets minus liabilities divided by the number of shares gives you the net asset value. Now, there's more complication than that, how you find the assets of the company, but once you find that out, it's a simple equation. Assets minus liabilities divided by the number of shares, it gives you net asset value per share. And that's what the person is entitled to. That's redeemable security. It's one of the big advantages of a mutual fund over a closed-end company, which brings me to the next subclassification, which is a closed-end company. Now, a closed-end company is any other company that doesn't issue redeemable securities. Now, there, the investor must look to the marketplace, to realize on his investment. He cannot turn it back to the company. He must go to the market, and some closed-end companies are listed on the New York Stock Exchange. And the investment, but there, most closed-end companies, unfortunately for investors, are selling at a discount of net asset from 15 to 40%. In other words, the market values the management that's being used by the investment company, and in many instances it values the management at about 15 to 40% below net asset value, which makes, generally speaking, the purchase of original issue of closed-end companies a poor investment, because conceivably the investment, a person buys a share at $10, and in 2 years it's down to $6, and the company may not have lost any money, may have gone on a regular, not spectacular, but maybe making conceivably 5 or 6%, and yet the market will discount that security. Some funds, closed-end companies, have sold at a premium. This is generally they sell at a premium, generally at a time when the investment company has made some very good investments and the net asset value is moving up drastically. For example, let us assume that the share was sold at 10, and in 2 years the net asset value is 17. The chances are the security may well be selling, could be selling at 20. I'm not sure that the example I gave you was a good one, because that would have only been 3.5% a year appreciation. But let's assume it made 12% a year. That the chances are that that would be selling at a premium. Generally speaking, the shares sell at a discount. Now, this doesn't make much difference to people if they bought in the aftermarket, in the secondary market, because they bought at a discount, and then the stock will vary, and it doesn't make any difference. But to those people who purchased original issue, there is a big problem. We have been faced recently with the advent of people trying to turn these securities, these companies, into open-end companies. By doing so, they immediately realize they bought at a discount, and an open-end company, you get net asset value, so they immediately have an appreciation of realizable proceeds. In other words, they'd go, in the example I gave you, you bought a stock at 10, it's now selling on the market at 7. If you make an open-end fund out of it, you can redeem at 10. So if you bought it at 7, you can pick up a 40% profit immediately. So that there has been in recent years an attempt to turn these companies into these closed-end companies into open-end funds.
Also, another thing that's been done is to give some people what may be looked as the equivalent of a redemptive right. For example, a company might make a tender offer once a year, or more than that, for the stock at the lower of the market value or the net asset value. And if everybody knows that that's what's going to happen, you might think then that the market value would gradually approach the net asset value.
Yeah. Now, the company's 5B further subdivides the company, subclassifies the company, management companies, into two types, diversified and non-diversified. Now, the use of diversified companies is a buzzword that connoted that the company was going to invest in a great many portfolio companies, and thereby it was a safer investment. The investor was not subject to the vagaries of the market in one company, but rather he was affected in the whole diversified portfolio. So those people who want to call themselves a diversified company have to do this. A diversified company must meet the following requirements. With respect to 75% of its assets, in other words, you have a pie and you take a 75% slice. With respect to that 75% of its assets, the company is limited to invest not more than 5% of the value of its assets in any one company, and not more, and it cannot buy more than 10% of the voting securities of any one issuer. So you have a two-prong requirement. One, only 5% of the company's assets, and that cannot exceed more than 10% of the portfolio's voting securities. Now, with respect to the other 25%, the small slice of pie, it can buy whatever it chooses to buy. So it could take that whole 25% and put it in one company and buy 50% of that company, if you will, of the voting securities. So the requirement is 75% has to be put into it has to be segmented into 5% of each, not more than 5% in any one company, and not more than 10% of that company's voting securities. With respect to the other 25%, no limit. Now, Section 5C says that a diversified company shall not lose its status as a diversified company because it cannot meet the qualifications for diversification if such failure was not caused by the acquisition of any particular security. What it means here is this, that let us assume that the company, when it acquired the securities, was very particular that it wouldn't acquire use more than 5% of its assets for any one acquisition. But it happened to hit a couple of winners, and they zoomed way up. Now those winners are 20% and 25% of the company's assets through market action. The company, because it was smart, shall not lose its diversification classification, because obviously it didn't get it by acquiring at the time of acquisition. Any questions? I'd now like to go into Section 7 of the Act, which is unregistered investment companies. Generally speaking, unregistered, the Act, Section 7, makes it unlawful for unregistered investment companies to offer for sale, sell, or deliver after sale, or purchase or redeem any security by the use of the mails or the instrumentalities of interstate commerce. Whether it's the issuer of those securities or whether somebody else is the issuer, it can't purchase or sell any securities. It can't offer any securities privately, which it has reason to believe that such securities will be offered to the public. It can control any investment company, any other investment company which does any of the acts which I've just enumerated. It cannot engage in business in interstate commerce. And it cannot control any company which is engaged in the business of interstate commerce. Therefore, what can it do? It can take reasonable measures to liquidate. That's what, in other words, it can sell its securities if the selling of those securities if the selling of the securities is designed as a method of liquidation. Now, that means, in interstate commerce, it really means that this company can't do anything, because a company, now, further, the Commission may take action under Section 42E of the investment company. Specifically, 42E says that in any proceedings under this subsection to enforce compliance with Section 7, the court, as a court of equity, may, to the extent it deems appropriate, take exclusive jurisdiction and possession of the investment company or companies involved, and the books and records and assets thereof, wherever located, and the court shall have jurisdiction to appoint a trustee, who, with the approval of the court, shall have power to dispose of any or all of such assets, subject to such terms and conditions as the court may prescribe. So here you have what I consider the ultimate enforcement ability. The ability, and I think up until this point, it was the only section of the Act of any of the statutes administered by the Commission, which gave us the power, which gave the court the power specifically to appoint a receiver or trustee. And we have, from time to time, used the power of the court in enforcement proceedings. One of most notable was the Fifth Avenue coach case. Are there any questions? Now, there's a little story about the enforcement. We had a case where the Real Silk Hosiery, a door-to-door sales of women's stockings, was considered an investment company. So we took the position that when that salesman got in and was trying on those stockings on the housewife, he was violating the Investment Company Act, as strange as it may seem. Thank you very much. We'll continue tomorrow.